am I right that the Supreme Court can legally accommodate 2 or 3 more justices? And what would that take? And can a president do that?
Why stop with 2 or 3, Sean? Sky's the limit. Look, the Constitution does not set a number of justices. It's gone down, it's gone up. It's been at 9 for about 150 years, give or take. Congress is free to add seats and allow the president to fill them at any time. And so when President Biden got into office and there was a lot of chatter about court expansion, I think even opponents recognized that would be constitutional. Would it be right? That's another question. But yes, absolutely, there could be justices added, even for the express purpose of changing the outcome. And as long as you do it through a law with a majority vote in Congress that the president signs, then that's that.
So Bill, go ahead.
Really quickly, another alternative, because that's going to obviously be very difficult. We used to have Supreme Court justices do something called riding circuit. And essentially what that meant was Supreme Court justices would go down to the circuit courts and they would sit in there, and you could bring up circuit justices to sit on the Supreme Court. So perhaps one might revive that practice too. It's unlikely, but certainly theoretically, if you're thinking about how to try to adjust the dynamics on the Supreme Court, that's certainly an idea that's also in the mix.
So Bill, I know Bill, if you can help us with this, everyone's heard of the Franklin Roosevelt court packing, right? So we know how that ended up, and in fact, eventually he gets the court that he wants anyway. But how did the court actually move up? Because Mark is right. At some point there was 7, then there was 8. Like what happened, and how did? I mean, we know about the court packing scandal, but how did it get?
Scandal is that's
right.
That's outcome determinative.
It looks better and better in retrospect.
Yeah. No. So I mean, it's something that we really have seen throughout the history, right? So, going back to John Adams, second president, he loses to Jefferson, and the Federalists in Congress say, you know what? There's a vacancy on the Supreme Court. We'll drop down the number of Supreme Court justices because we don't want Jefferson to fill it. So they pass a statute. And then Jefferson comes in with the Republicans and they say, no, we want to fill it. So they go back up. So it really is something that has been...
And that was the first time anything like that happened.
Yeah, but that's 1800 and 1801. So, I mean, this is really something that, we've seen up and down throughout our history. Now, I think the thing is, since the Civil War, it's been fixed. So Roosevelt tried to expand it. It actually was a closer call. If things had broken right, he would have been able to expand the court. And basically, if he'd wanted to expand it by 4, he could have walked through, he could have done that very easily. So, what we're grappling with now is, though, for 150 years, we've been fixed in terms of the numbers. So it feels like it's outcome-oriented to change it.
All right. Here's a question. This actually relates to one of the cases we didn't talk about. I mentioned it briefly. The SEC case where the court, again, it's a Chevron, no longer deference to the SEC that says, look, you guys have your own courtrooms, and we don't think that's constitutionally appropriate under federal law. You have people who are being subject to your federal regulations deserve to be in a courtroom, not in your courtroom. So someone here wrote, given that the SEC wins about 100% of the cases it brings to its administrative courts. You've had experiences, I see. I'm one of those 100%, versus 60% brought in federal court. So that's an interesting, this person knows the statistics. You lose to the SEC 100% of the time in their courtroom. You lose 60% of the time in a federal courtroom. How can the SEC be judge, jury, and prosecutor be fair? So this person is making an anti-PhD, don't take it personally, Bill, but it is about you. In the end, it's you. This person's basically saying, if it's so inside baseball with federal in a regulatory atmosphere, we have no chance, and give us a chance because these other people are unelected, yes, highly educated, but unelected.
Well, I really think they should take that argument to Congress where it belongs. Congress changed this law in the Dodd Frank Act after the recession. It felt that the Justice Department and the SEC did not have sufficient personnel and resources to go after all of the civil fraud that was occurring.
So wait, so this is a post-2008?
So this is a post-08 reform. So they
wow.
gave the SEC the authority to impose civil penalties through in-house adjudication. A federal court gets to review all of those adjudications and the ultimate determination for due process compliance, or at least it did until this decision. I also think that part of what's going on here is the causation, the question might have the causation backward. If someone is guilty and they think they're going to lose, going to federal court is really not necessarily the best idea. Civil juries tend not to like civil fraudsters and can sometimes impose pretty major penalties. If they go in-house, it might be a safer bet, a safer gamble. Sure, they'll be found guilty, but they might have much less of a payout. And the reality is, I like juries. I don't mean to demean juries. And I'm sure if any of you in this room got on a jury involving civil fraud, you would fully grasp the intricacies of the law and render a fair decision. But I do not think that you are representative of the American public. And I think the problem is that many people on those juries don't fully grasp the issues the way that an administrative law judge who is trained in this, who has deep experience and knowledge, can apply consistency and principle to case after case and come up with a series of decisions that are fair and just.
Another strong argument in favor of the Chevron deference. All right, before we say goodnight, CLE code for those of you online in order to get your credit. TR, like in Thane Rosenbaum, TR 0321. TR 0321. So Law of the Land just finished its 9th year. Its purpose is to make the Supreme Court accessible, knowable, interesting, entertaining. I think that you did such an incredible job of opening its doors. This stuff is, for many people, opaque, even for lawyers. And I think people also, I think one of the things that I didn't get a chance to say, one of the themes that came up with Tiffany, Bill, and certainly with Mark, is the way they describe the politics within the court, right? What you were really describing was politics in the decisions, how they get written, who's saying it, why they're saying it. What's interesting is that the AP just did a poll, and it said, we know that Roberts is concerned about the declining public confidence in the judicial independence of the court. But 70% of the people believe that the court makes its decisions purely on ideological reasons. And it has nothing to do with the law. It's just purely ideological. That is a stunning number. And I thought that that's one of the things that I think you also opened up for us about how one can draw those conclusions given the way you described how the cases get selected, right? The strategies and how they lead them up and who they assign them to and what they say in their various opinions.